the difference between the strikeout, unless order, and deposit order in Employment Tribunal, and when should you think about using each one? All three of these are tactics that employers often use, especially the strikeout and deposit order, to either intimidate the claimant to drop their claim or to try and get the court to just throw the claim out, often right at the beginning of the process. But you can use all three of these and they can be very useful tools in your arsenal, either for putting pressure on the respondent or to actually get them to do something when they're not behaving as they should be. So let's start with the strikeout, because this is probably the one that people are most familiar with because employers often use it. And the way that they use it is right at the beginning of a case, they will file for a strikeout saying that you have no reasonable prospect of success, which is, pretty bold. But actually you can use strikeout as well if they are not complying with any of the rules or with the order of the tribunal. But is always the strikeout the first place to go? Let's look at the unless order. If your respondent isn't actually playing by the rules, not giving you information, not disclosing something, not obeying the case management orders, then you should typically go with the unless order first, because that's the or else. Unless you do this, then we will strike out your claim. So typically a tribunal will expect you to use an unless order first before you go straight to strikeout, unless it's pretty egregious. The third one is the deposit order. And again, employers will sometimes use this as an intimidation tactic to try and make the claimant have to pay up front because they say that they don't have a good case, and so they're trying to scare the claimant away. Now, the deposit order has a lower bar. So you'll notice here in point 29, it says a claim or response has little reasonable prospect of success, unlike no reasonable prospect, which is what we saw when we saw the strikeout. So it's a lower bar. And what they're saying is a particular part of your claim or your response, if you want to keep pursuing that, you're going to need to pay up to £1,000 to continue pursuing it, because we think it's on shaky ground and you're really going to need to put up in order to show that you really believe this. So if your employer is pushing a line that is ridiculous, say they have told you that there's a document that exists that proves this thing and you know the document doesn't exist, then that could be a good way of forcing them to show their hand or forcing them to face up to the fact that it doesn't by asking for a deposit order. All three of these templates are available to purchase on the VALA website. They're affordable and we can help you check over them once you've written them.